Good afternoon, everybody. This is Whitney O'Reilly. I am the chair of our wealth department here at Cohen Seglius. I know as people are scrolling in, I'll make sure I don't start talking about any really important information. But today we're going to talk about your estate plan and how a divorce affects your estate plan. And so this could be something that you're thinking about for yourself. You're thinking about a divorce, you're in the middle of a divorce has been finalized. This could be happening to one of your children. This could be happening to a friend. I would like to say neither of these situations would ever affect you, death or divorce. Unfortunately, no matter what, at least one will affect you. So it's important to understand a little bit about this background. Again, many of you join my Lunch and Learns. I try to do this every month or every couple of months regarding a topic that's really important for my clients, potential clients, family, friends. Remember, if you have any questions during this presentation, you can put them in the Q&A below. You can also send me a chat. If I think it's something important for the group, I will certainly talk about it. If I think it might veer us off topic, I will certainly reach out to you afterwards. After this presentation, we do send this recording to you, including our information. So if you ever have any questions, certainly reach out. If there's any other topic you'd like to know about or have an upcoming thought about, certainly send it my direction. Always happy to do a lunch and learn about anything. Again, this one sort of popped into the purview for me. I have two cases that we're going to talk about where we have a situation where somebody's passed away and we've got something going on with a divorce. So I'm going to talk to you about that. And the other reason this came up is because normally these lunch and learns are just me talking to you from the wealth preservation section of our firm. But today we have the chair of our family law section here, Carolyn Daly, who is going to chime in when it comes to something specifically divorce related. So the way that we're going to start this, and I just want to make sure it looks like we've got a bunch of people in now. Wonderful. So the way that I'm going to start this is that I'm going to explain what an estate plan is, because that's really important to understand if we're thinking about divorce, if we're in a divorce, if we've gotten divorced, what's included in your estate plan. So your estate plan includes the following documents: a financial power of attorney. That's the document that comes into play if for whatever reason you can't make your own financial decisions. Who pays your mortgage? Who pays your utilities? Who makes investment decisions for you while you're in a coma in the hospital on the brink of coming out of, hopefully, that coma from a car accident? The same, we've got a medical power of attorney. That's the second piece of your estate plan. That medical power of attorney, again, is appointing someone to make medical decisions for you if you can't make those medical decisions for yourself. We also have something called a living will. Sometimes it's called an advance directive that says what you do or you don't want at the very end stage of your life, whether or not you're an organ donor, including some other information. And then the last piece of your estate plan is your last will and testament or revocable trust. Now, we've spent many other webinars talking about whether or not you should have a will or revocable trust. So maybe go back and look at my page if you have questions on whether or not you should have a last will and testament or a revocable trust. But we've got that last will and testament that says who's in charge of taking care of things when you're not here anymore and where those things go. So that's an estate plan. And I'm going to sort of turn things over to Carolyn for a second and say, now we know what are the main documents of an estate plan. Of course, everybody should have these documents because we don't know at what point we may or may not be incapacitated. And unfortunately, we are all at some point not going to be here anymore. So having the right people in place and having the right people to make the right decisions and having your assets flow the way you want them to is really important, whether or not you are in a divorce situation. But when we're in a divorce situation, I'm going to have Carolyn sort of take over and talk to you a little bit about the practice group here at Cohen Seglius, the family law section, and then just a little bit about the divorce process as we start talking about what problems can occur if we have a divorce situation at play. Carolyn?
Thank you, Whitney, and welcome everyone. Nice to be here, and let's talk a little bit about the divorce process and as it impacts sort of your estate plan. I think that when people get ready to come in and see an attorney and handle a divorce process, they often forget about their estate planning documents. And I think that they are some of the most important documents to provide your divorce attorney with, so that that attorney can review the documents in order to determine what changes need to be made when and how quickly. So for example, I always tell my clients that if you are at the point of filing for a divorce, that you need to change your will immediately, and probably your advance directive, your living will, and your financial power of attorney. Because in the event that something should happen to you, and we can talk about this a little bit later, during the time of the divorce, that will may still govern, despite the fact that you have filed a complaint for divorce and intend to divorce your spouse, which becomes very dangerous and becomes very involving for other people and may put you in front of probate court and not in the family court. So you want to be sure that you have those things properly addressed. I also tell clients that if you have trust documents, whether it's your estate attorney or your divorce attorney, one of them needs to look at those documents to determine what, if any, changes need to be made to those documents. Some trust documents automatically revoke the spouse as a beneficiary or as a trustee upon the filing of a complaint for divorce or upon a separation, and others don't. And so those things will remain in place and in the event that something should happen to you during the divorce, which is difficult. So another thing that I also think is very little known or discussed, and something that quite frankly I was unaware of until my daughter went to college, when your children turn 18, they then have the right to make decisions for themselves. They may not really be quite adults, but they are entitled to privacy and all of these other items. Now, if you're in a divorce situation, your child is 18, 19, she's at college, something happens, the two parents can start fighting about what is to occur. And in a divorce situation, neither one of you may have the right to make a decision in an emergency situation. So having your children, when they turn 18 and are ready to launch into the world, have their own power of attorney, a financial directive, advanced medical living will is important, because again, those documents will then decide which parent or both or how things are handled in the event of their incapacity, which people don't think about. And so I think those are also very important documents to handle. So that's really the outset and the beginning, Whitney, of the divorce process, and how these documents, these estate plans, can impact and be helpful or create problems, which we can talk about.
Yeah, absolutely. And what I would say is, especially when it comes to your children, we just started the school year. Many people have just left for college. I tell each and every family, whether we've got a divorce situation or not, when those children turn 18, you no longer have authority to make decisions for your children, access information in the event of some kind of situation. So what I often encourage families to do is have your child come in. Let's get a financial power of attorney signed. Let's get a medical power of attorney signed. Maybe even let's get a last will and testament signed for the things that maybe they have in their individual name. Get that process started. Even more important, I think, if we have a divorce situation, especially because things aren't always acrimonial, which is who does make that medical decision if we're in a really difficult place. Maybe it's mom, maybe it's dad, maybe it's both mom and dad, maybe it's either mom and dad, maybe it's aunt, maybe it's uncle, but getting those documents in place can be really important. One of the things that I experienced during COVID-19, when we had the pandemic come into play, we had people with COVID-19 on ventilators. They had individually held assets. And if you remember, this is what the market was doing. And so family members were frantically reaching out to their estate attorneys like myself and saying, how do we access these accounts so that we can either buy stock or sell stock or make some sort of decision on something happening while our loved one, we hope, is going to come off of this ventilator and be okay, but we don't know what the future holds. And the answer is, if they didn't already have an estate plan in place with a financial power of attorney, there is nothing shy of getting a guardianship through the court system in order to accomplish that. And a guardianship costs a lot of money, takes a lot of time, and puts the decision-making power in the court's hand and not yourself. And during the pandemic, even worse than that, the court systems were closed. So for a period of time, we didn't even have that last ditch avenue. So really important to have that estate plan. And that actually leads me into the first question that we have, which is a great question, which is, what is the best way to make sure your ex does not indirectly receive money if your child passes away? My child is my heir, right? And a father and a stepsister, they're both alive. And a lot of times, and Carolyn, you probably heard this many times, what does happen? Certainly, my daughter is out today. It is, and I shouldn't be saying this on a live webinar, but I'm going to, but she is on senior skip day. She may or may not be skipping school and going out for lunch, but it's raining out, right? So it's something a parent worries about. I don't want something to ever happen to my child. As an estate attorney with 20 years of experience, there are many times that children pass away before their parents. How do we make sure that that money doesn't wind up in the hands of your ex-spouse? And the answer is, and Carolyn talked about this earlier, is having an estate plan in place that has a trust for your children so that you dictate how that money is used for your child's lifetime and what, if anything, happens after your child passes away. So when you get divorced, if you're thinking about divorce, even if you're not thinking about divorce, if you're someone like me who has a minor child, you want to make sure underneath your last will and testament or your revocable trust that you have some kind of trust provisions in place so that we've got creditor protection for your children. We even have marital protection for your children. That trust actually protects those assets better than a prenuptial agreement. Now, do I think we shouldn't have a prenuptial agreement? No, I think a prenuptial agreement is a great idea as well. But people who are getting married for the first time, never do them. So this is a way that you can protect your family members and make sure that your assets don't go, let's say, to an ex-spouse who shouldn't be receiving those funds. So great question, and that's my answer. And I'll say, Carolyn, would you like to add something to that question or that answer, that updating your estate plan and including a testamentary trust is really important to make sure your ex doesn't get money from you or your children if someone passes away?
So great answer, Whitney. And actually, it was something that I talk to clients about quite frequently. I suggest to them that upon the divorce, they should be thinking about trust and using those assets or that vehicle in order to protect monies that may pass to a child, that may pass to someone you didn't intend them to pass to under a will. The trust passes, anything in a trust passes outside of a probate court and really will be a better way for you to obtain what it is that you intend to occur on your passing and even potentially in the event of your child's passing. And so I often say to clients that trusts are overlooked and should be used in terms of securing assets, not only for you, but for the future. One of the trusts that we deal with quite frequently, and I think most divorce lawyers are probably most familiar with, are special needs trusts. So those are trusts involving a child who may or may not ever be what we refer to as emancipated or capable of supporting themselves. And you have parents who may or may not then be relieved of the obligation to pay child support for that child beyond their age of majority. And a special needs trust is a really good vehicle to use in order to ensure that that child is supported and that that child will receive public assistance benefits that they may not receive if, in fact, each of the parents is providing them with support. In other words, the lack of a trust vehicle would defeat the ability to obtain many public benefits that are otherwise available. So, Whitney, I agree with you. That is one way in which I think trusts can and should be used in a much more efficient manner, particularly when it relates to divorce.
Yeah, absolutely. We draft special needs trust on a pretty constant basis. I will say some newer special needs trusts, we're able to toggle a child who you are not sure if is going to be able to fully function on their own, or if you're not sure if that child will qualify for certain government benefits. We have the ability to sort of toggle on the special needs provisions or toggle off those special needs provision and just have a more generic, easier to administer trust. So it can be really important, even if you have a special needs trust under your plan, from time to time, revisit that depending on what's going on in your lives and what's going on in your children's lives. So Carolyn just said this word that lots of people don't understand, which is called probate. What is probate, right? What is that process? People always say, what's in your probate estate? And the answer is probate is the court supervised process of transferring individually held assets either through the intestate law of the state or through their estate planning documents like last will and testament or revocable trust. And the only things that flow through probate are individually held assets. So let's talk about your estate as a whole, because that's really important when it comes to things like divorce, which is you might go in and say, you know what? I just got divorced. I'm going to change my will. I'm going to take my spouse out as the executor. I'm going to take them out as a beneficiary of my estate. But you forgot that you had them as the beneficiary of your life insurance policy, or you forgot you had them as the beneficiary of your 401k, or your IRA, or your SEP IRA. Or let's say you own business interests together inside of a business entity, or you jointly own assets, whether by tenants in common or with joint right of survivorship. So the way that you hold assets can determine how they transfer when you pass away. And in most estates, there are probate assets and non-probate assets. And when it comes to divorce, those things can be affected differently. And here's my first story to tell us, and that's what made me think about this webinar today, talking about your estate plan, your will, and divorce, which is, I had a gentleman pass away. He left all of his assets through his last will and testament to his only 2 children. He had 3 wives, all of which, 2 of which, passed away before him. His second wife was still living. We administered the estate. Part of the way through the estate, we were reached out to by his employer that there was a very large life insurance policy insured on his life, and that the beneficiary was his second wife. This was a very large life insurance policy. So what we did, this estate administration was here in Pennsylvania. Remember, Cohen-Seglius, we represent clients in multiple states here along the Northeast. So we go all the way New Jersey, Pennsylvania, New York, Delaware, Maryland, Virginia, DC. We even have now opened offices in Florida. So remember, when I'm telling these particular stories, it is often very state specific. So depending on what state you live in, the result may be something different, or it may be the same, depending on the federal treatment of this particular asset. But in this case, our argument was, in Pennsylvania, the law that guides estate administrations is called the Pennsylvania Estate and Fiduciaries Code. Under 6111, there is a section that says, if you get divorced and you forget to go back and update these estate planning documents, which none of the people that are listening to this will forget to do because you're here listening to it and know that it's really important. But if you forget to do that, there's a default state law in many of the states we practice in many of the states in the United States, but not all, that says if you forget to do some of these things, we understand that most people would not want their ex-spouse to inherit. So unless there are circumstances that show that you specifically were changing or keeping the plan the way that it is to give to an ex-spouse, we're going to consider that ex-spouse to have predeceased you, and then the contingent through your estate planning documents will control. And so you might say, well, that'll do the trick, Wet. We don't even really need to listen to this webinar without doing anything. As long as I live in Pennsylvania or another state that has a similar law, it's going to update it for me. And I can save some legal fees by not coming in and updating those documents. Well, the answer is, it doesn't actually do it for all documents. It depends where you're at in the divorce. Sometimes you're not far enough in the divorce and it doesn't count yet. Or you can have a situation like this situation, this estate administration, more than $1 million in life insurance is going to a second spouse. Now you'd say, Whitney, we just talked about this PEF code section that says he, of course, was divorced. There's no timing issues. He divorced that spouse 25 years ago. I'm sure the contingent beneficiary should control, and those assets should go down to his children. And the answer is, if it was not a life insurance policy through his employer that was based on the laws of ERISA, which is federal law, if it was a state controlled life insurance policy, the answer would be yes. We would count that ex-spouse out and the money would go down to the children. Unfortunately, in this case, it was an ERISA guided life insurance policy through an employer. And the federal law, as of today, as of September 26, 2023, there is no right to revert back to a previous beneficiary designation, to that contingent beneficiary, to whatever that company's policy on a default beneficiary designation is. The policy stands as is unless the beneficiary updated that account. So in this situation, we had millions of dollars going to an ex-spouse instead of down to her children, his children. And the answer might be, well, couldn't we talk to that spouse and say, spouse, you really weren't involved anymore. Could you please just give that money back to the beneficiaries? And the answer is, in the 20 years that I've been practicing, nobody gives money back that they've received. So that's unlikely. In this particular situation, even worse, the second spouse may very well have given those funds back, but she was in a nursing home, incapacitated, and the care facility was acting as her guardian, so did not have the ability to say, we don't want funds coming into this beneficiary, because they didn't legally have the ability to make that decision. So this is sort of a word of warning that says, Pennsylvania and other states do have some default provisions that say if you haven't updated your estate plan, during that divorce process or after that divorce, if you haven't updated those beneficiary designations, change the titling of your assets, we'll come in and help you out. And the answer is, it's not seamless. The most seamless thing to do is make sure that your estate plan is updated in accordance with your wishes. And I'll sort of turn it over to Carolyn and say here, because sometimes we have a divorce decree, or sometimes we have an asset that has strings to it pursuant to that divorce that we need to understand in the estate planning document. So tell me a little bit about that, Carolyn.
So thank you, Whitney. Perfect transition. So I do the same thing when any one of my clients after a divorce receives what I refer to as my checklist closeout letter, which literally spells out everything you should be doing, including redoing your will if you have not already, reviewing your trust documents and revising as necessary, looking at your medical directive, your general power of attorney, and making the revisions. I also tell you that you need to go look at your life insurance policies, your pensions, your 401ks, your stock option plans, your ERISA qualified plans, which same thing, deferred compensation, and change the beneficiaries. Do it, because it is much easier to do that than to forget to do it and then have something happen later on. I have a similar story, and Whitney and I did not prepare these together, but I have a similar story in New Jersey, which I am unsure has that default provision that Pennsylvania has that says, in the event that you are divorced, we're just going to revoke those provisions. I will tell you, ERISA does not. And my story involved an ERISA plan. Husband had been divorced, remarried, died soon into the marriage, 3-4 years, had a 2-year-old daughter with the new wife. And when he passed away, he had forgotten to change his pension beneficiary. And trust me, the first wife was only too happy to receive that money, and litigation ensued with arguments about, well, that would be unfair. That means first wife got more than she should have. And those arguments continued. And I, at the time, had to do the research on the federal level. And that, again, it is the correct law still, September 26, 2023, that if you do not change your beneficiary on an ERISA governed plan, that beneficiary will receive. The only exception, which is the exception I learned 20 years ago, very early on in my practice and include in all of my divorce documents, is unless there is a specific waiver of the beneficiary provision and the right to receive and to remain as as a joint survivor annuitant, or to receive any documents, unless your divorce decree says spouse waives any right in and to the plan, including their right to remain as beneficiary thereon and or to receive any money therefrom, ERISA governs, they get the money. If your divorce decree contains that very simple small language, which I found 20 years ago, then the first spouse will not. It acts as a revocation, despite the fact that you did not change the beneficiary provision, and the money will pass in through your estate. So it's very tricky, as I'm sure you can tell. And the point of all of this is make the changes. Look at your documents. If you don't, then you end up with either Whitney or I trying to straighten it out. And that is a problem. One of the other situations that I have been involved in more than once is parties begin the divorce, nobody changed their will, and someone dies, whether unexpectedly or was suffering with cancer, and are very clear they do not want that spouse to receive anything. They want it to pass as if there was a divorce and the money will have gone through their will. At least in New Jersey, and Whitney is correct, this is not every state, but in New Jersey, we have what I refer to, what many of my practitioners refer to as the black hole. It is very unclear as to whether the divorce should proceed and the estate will stand in the shoes of the person who died and finish the divorce, or if the divorce should be dismissed and the matter moved to probate and the will control. And if you have not changed your estate plan documents, it won't matter. It's still going to pass, whether it's in probate or through the divorce process, as if that person had decided you were going to receive these assets and this money that, quite frankly, I've had more than one client tell me they absolutely did not want to have occur. My answer to them was, where's your will? Where are your estate plan documents? Because they need to be changed immediately. So it just goes to stress the other reason why it is so very important to update these documents and be sure that what you are intending to occur will occur. And that requires, yes, people to look at these things, even though maybe, as I say to my clients all the time, now that the divorce is over, I'm sure you are happy and you have some peace, but you still have a little work to do, because it's not complete until you have done all of these things and more, because my checklist is probably 3 pages, if not longer, because I've for many years sat down to think about what is it that people often forget Life insurance is a perfect example. People never look at their life insurance. I mean, they can think about those things like, the bank accounts. They want to make sure that their spouse is not on any of those. They can think about a house because you're likely transferring a deed, or maybe your pension, you might remember, because it's a big asset and you tend to, contribute to a 401k or a pension. You get reminders, but life insurance is a perfect example of something that gets overlooked. And so it is imperative that you think through beneficiary designations on all of these assets. Most importantly, if they are ERISA governed, because it takes the ability for us in the state level to be able to help you, because trust me, the federal government does not bend. So those are my thoughts.
And that was a perfect lead into anyone who's been on these webinars before knows that I like to ask questions. The first person to answer that question correctly, I send a little gift to. So as we're talking about life insurance, my first question for today's webinar is regarding life insurance. So again, the first person to answer the question correctly gets a gift. So that first question is, we talked a lot about life insurance having a beneficiary designation, making sure that we update life insurance beneficiary designations, because we have possibly some state law defaults, but we have a federal overlay that does not account for that. Although we could have a great divorce attorney who puts special language inside that divorce decree or those final divorce documents that knocks it back out for federal purposes. But even better yet is putting the beneficiary designation we want. Now, this is something we haven't talked about, but I'm going to see if anybody knows the answer, which is life insurance taxed for Pennsylvania inheritance tax purposes after somebody passes away? Life insurance is part of your estate administration, but is it what gets taxed in your estate? Oh, and we've already got an answer. Let's see. Wonderful. The answer is it is not taxed for Pennsylvania inheritance tax purposes. But for anyone else on this webinar who, let's say, is in a different state like New Jersey and says, wait a minute, I'm in New Jersey. There is actually a New Jersey inheritance tax. There used to in New Jersey be two death taxes that came into play, the New Jersey estate tax and the New Jersey inheritance tax. 2018 got rid of the New Jersey estate tax. We do still have the New Jersey inheritance tax, but if your spouse or your children inherit, they are exempt from that tax. So it's a little bit kinder version than Pennsylvania's inheritance tax, which is taxed when it goes down to children or grandchildren. But for federal purposes, this is my second question. For federal purposes, remember, just like for an individual, we pay income tax at the state level and the federal level. For death purposes, we pay tax at the state level and the federal level. So there is a federal estate tax. Is life insurance included in your estate for federal tax purposes after you pass away? So remember, the answer already was for state purposes, at least here in Pennsylvania, it is not included in your estate for inheritance tax purposes. While we're trying to figure out that answer, I can tell you life insurance could be considered part of your probate estate, or it could be considered part of your non-probate estate. And the reason is, if life insurance doesn't have a beneficiary designation and the custodian of that life insurance policy's default is that it is payable to the estate, or you have a policy that's payable to the estate, it will be re-included in your probate estate. If you have a named beneficiary, it will be a non-probate asset. But is it included for federal estate tax purposes? And I'll give people one more minute to see. Is the answer yes, it's included for tax purposes? Or just like Pennsylvania, it's not included for tax purposes? Because is it really considered your asset, right? It's life insurance. Looks like nobody knows the answer to that. Well, I'm going to tell you the answer. For federal estate tax purposes, it is absolutely included in your estate for federal estate tax purposes. The federal estate tax when you pass away is a 40% tax. So it's a big gnarly tax, whether it's pre-divorce, post-divorce, really important to understand how many assets you have and whether or not those assets are includable for tax purposes. So again, sort of the end that section, really important to look at your assets that have beneficiary designations, because whether or not we've got provisions or we've got state law defaults that can help fix problems if we have already gotten divorced, the answer is it's not 100% unless we go in and update those beneficiary designations. Remember, things that have beneficiary designations, life insurance, retirement accounts. Retirement accounts include a 401k, a 401(3). It includes a SEP IRA. It includes an inherited IRA. It can include jointly held assets. Sometimes I've seen stock accounts with beneficiary designations. Oftentimes that's not the case, but we could have something like that. Really important to circle back and look at that whole estate plan. I normally tell clients every 5 to 7 years, or when a major life event happens, like divorce, is when we circle back and make sure that our estate planning documents account for what we want them to say. One of the questions that I get from clients all the time who are thinking about divorce or beginning that divorce process are, am I allowed to do that now? And I'm going to sort of hand that over to Carolyn to say, are we allowed to update our estate plan during the divorce process? Are we allowed to change beneficiary designations? Can we move money around? That's a big question I get from clients. And take it away, Carolyn, and fill us in a little bit about, we're saying update your plan, update the way you hold your assets, but when is the right time to do that if we're thinking about a divorce or we're in a divorce proceeding?
So my answer to that is as soon as possible. I think that everybody waits until the end because of those questions and, whether I can move things, whether I can change things during the divorce process. And I'm dealing with the divorce process, so it's just too much to add. But the answer is, and particularly in New Jersey because of the black hole issue, it's you do it immediately. You can absolutely make changes to your estate. I often say to people that when you get married, that's the I do contract. And when you file for divorce, it's the I don't. And when you don't, then you get to make those changes because that person is no longer, your soon to be ex-spouse is no longer entitled to receive all of the assets. How we will deal with some of the assets during equitable distribution and dividing them as part of the divorce is separate, in my view, from the estate planning, from trust documents, because in a trust document, the intention is often to shield or to protect or to pass outside of probate an asset. And if the trust document itself is going to revoke your spouse as being a beneficiary or a trustee, why not just get it done? Why not just make sure that it is done? Because you're not doing anything nefarious. You're not doing anything that is wrong. You are allowed to do it. And if there is an issue as to whether or not the trust is subject to equitable distribution, and we could spend a lot of time talking about that, there's case law in New Jersey and in several states that conflicts and discusses when a trust is or is not part of equitable distribution. But it's one of the reasons why I say, if you have a trust, and I have a client who has 5 trusts, and the first thing I did was call the estate attorney, the estate trust and estate attorney, and said, we need to get on the phone and you need to walk me through these trusts because I need to understand them inside and out, because there are arguments to be made in my area of law during this divorce that I need to understand these the way you understand these and how they have operated over the years. So to me, making sure that those documents are correct and making sure that the assets that are in those vehicles, particularly a trust, obviously, are protected as you had intended them to be. It is important to review those at the outset of a divorce proceeding. And I think that people often wait too long and we run into trouble because they either forget or the change is something that can't happen. But If, for example, there was something within a trust that would be divided during a divorce, you can change the trust documentation. That simply means that at some point, with the assistance of the estate and trust attorney, some of the assets may need to be transferred out, or those assets will remain, and another asset that you will be dividing in the divorce may go wholly to your ex-spouse, because we are offsetting it, because we say the trust vehicle will not allow for the transfer, so therefore we have to leave it intact. But we have a house, or we have an investment account, and we can take that asset or those assets and equalize what the intention was without destroying the trust asset. I will give you, on that note, I'll give you another interesting, difficult issue where I was pulled in as the attorney for the children who were the beneficiaries of the trust. In other words, mom and dad were getting divorced, and what mom and dad were going to do with trusts in the context of their divorce was going to have very bad implications for the children, who were young adults, but adults who reached out to me to intervene. In other words, to become part of that divorce process. Yeah, lots of fun. And to try to prevent it. The parents had real estate trusts, and the real estate trust held two separate properties. One was the marital residence in New Jersey. The other was a vacation home in the Hamptons. So you can imagine what the size and value of that property was, but even the marital residence was significant. And the parties and their lawyers, whom I love, and their lawyers, we're trying to divide those properties, and we're talking about, well, mom will keep mom's going to keep the New Jersey property, and dad's going to keep the property in the Hamptons. And I kept conveying to the judge, who didn't quite get it initially, I don't know why we are talking about these properties, because they are no longer assets of this estate. This marital estate no longer owns them. They are in trusts. And so we cannot move them like they are chess pieces on a board. They are outside of this divorce process, and they are part of these trusts. And judge, if you permit these parties and these lawyers to do this, you will reverse the gift that was made into these trusts of each property. And guess who will be paying the taxes on the reversal of that gift? The children, because they are the beneficiaries, and they would be the ones that would have to pay the tax if, in fact, the trusts were we call unwound, broken, if they were destroyed, which is what the parents were talking about doing by trading properties. It took a little explaining. It took a lot of writing of briefs and explaining the law, and ultimately the court agreed with my position. And then, as judges, at least in New Jersey, like to do, sent us off to mediation to make it go away, because the judge didn't particularly want to deal with the issue. And we were able to do that. We were able to resolve it out and finally explain to a very seasoned mediator why this was a bad idea, but that if the parents wanted to do it, they would be the ones indemnifying, meaning making sure my clients, the children, would not be paying any of the taxes. They would be paying the taxes. So again, just something else when you are dealing with in a divorce situation, trusts become very tricky. They just become very tricky, which is why I say to people, it's very important at the outset, if you have trust, to gather the trust documents. Get the lawyer who drafted the trust documents on the phone with your divorce lawyer. You may also want to talk to the tax attorney, because if there were gifts made into this trust that may be impacted by the divorce, or actions someone thinks are going to take in the divorce, you want to know that. You want to be prepared for that. And you want to have that up front, not 3/4 of the way through the divorce when you say, oh, by the way, I have this trust. And your lawyer looks at you and goes, what trust? And why didn't you tell me at the beginning? Because even though you don't own it, it is sort of still an asset that may have some income that you receive from it, that is something I need to disclose in your divorce. And you're telling me now. Okay. it just makes it more difficult, because then everyone has to sort of pause, reverse, get everybody involved and figure out, is this going to screw everything up that we just did, that we're ready to settle this case? Or no, it's okay, it doesn't have an impact, but you need to change your trust document because you are getting divorced, and that's something you need to do now sooner than later. So those are the reasons why I think that it's very important to address these things at the outset of a divorce.
Absolutely, Carolyn. Yeah, I mean, I always tell clients, you involve your whole team when it comes to, let's say, updating your estate plan. Do we want your financial advisor involved? Sure. Do we want your accounting firm involved? Sure. Do we want your business accountant involved? Maybe, depends on the situation. Do we want to talk to your divorce attorney if we've got this trust in place and you're thinking about getting a divorce? Absolutely. And what I would say in regards to advanced estate planning, and I think that may be one of our next webinars, which is I've got enough money that I'm okay for my whole lifetime. What can I do for my children now or in the future? Probably like that divorcing couple that Carolyn just told us about, as in putting a trust together and putting some assets into that trust to get a preferential tax treatment during lifetime or after somebody has passed away. In addition, getting creditor protection, marital protection for successive generations. But understanding how that advanced planning may affect you if you get divorced. And one particular piece of advanced estate planning that we've seen a big uptick of in the last couple of years, because the estate tax exemption has gone from, well, 600,000 not that long ago to all the way up to $12.92 million. And if we draft the right kind of estate plan, we can actually shelter that from each spouse so that a family doesn't incur that 40% estate tax until basically we're over $25 million. So we've seen an uptick of using up some of that exemption during lifetime so that families aren't subject to that 40% tax. One of those particular types of plans, and we'll talk about this in another webinar, is called a SLAT, a spousal limited access trust. And they can be very helpful for income tax purposes and death tax purposes for ultra wealthy clients. But if they get divorced during their lifetime, they actually gave this asset to this other individual, and it may not be able to just be unwound or brought back in. So it's really important to understand when we do that advanced planning, when we stick money in a trust for children, when we stick money in trust for, let's say, a spouse, maybe we do an irrevocable life insurance trust, an ILET, to sort of get some life insurance out of your estate. Because remember, we talked about it's in your estate for federal estate tax purposes. Understanding what are the ramifications during your lifetime if something changes. And an example that I'm working on right now, I've got a charitable trust, a charitable remainder annuity trust. And the problem with this trust is it's irrevocable. People had a great deal of money, and then the company went under, and they reached back out to me and said, can we have the money that's inside this trust? We need it back in order to bring our business back to where it needs to go. And the answer is, it's not your money anymore. Just like in that situation, it really wasn't the parents' money anymore. It was the children's money. And now we've got the children's assets and the children involved in, hopefully, what should keep them out as much as possible from that divorce situation. So it's really important to understand your whole estate plan and how it can be affected in that divorce. And I think what Carolyn is saying, which I think is really important because I get this question on a constant basis, is when can I fix things? When can I look back at my estate plan? When can I make adjustments to what's going on in my plan? And the answer is immediately. You immediately get legal advice on what you should or you shouldn't be doing moving forward with your estate plan and your divorce proceeding. And I think we had one follow-up question regarding life insurance, whether it is included in your estate for state level death tax purposes or federal level death tax purposes. And the question was, we have a caller on this webinar from Delaware. Well, is life insurance includable for Delaware tax purposes? Well, this is a great answer, which is There is no Delaware inheritance or estate tax, so it's not in your estate for death tax purposes. But if you do live in Delaware and you have a larger estate, it absolutely will be includable for federal estate tax purposes. And one of the things that we didn't talk about, and we'll talk about when we talk about advanced planning in another webinar, is right now we have that $12.92 million that we can shelter from the federal estate tax. But the law that created that large exemption, the Tax Cuts and Jobs Act of 2017, that law is sunsetting. It's reverting back to $5 million per individual. So there are going to be a lot more people, whether on this call or otherwise, that certainly care about those death tax ramifications. Now, you might be saying, death, Whit, I thought we were talking about divorce, but they go together. Because if, let's say, you're divorced and you pass away and you didn't make changes to things, that involves that ex-spouse and even some of those tax considerations. So we have just a couple of minutes left. I'm going to tell you one more story. I had 2 cases recently that led me to say, you know what, let's talk to clients, let's talk to potential clients, let's talk to family and friends about divorce, because if you have a family member going through a difficult time, it is really important to circle back to those estate planning documents. I had a case recently where I had a divorcing spouse passed away in a very untimely situation, and the surviving spouse, who was in the middle of a divorce, by Pennsylvania purposes, was still considered the executor and the primary beneficiary of the estate, because they hadn't gone far enough in the divorce proceeding to bring in that Pennsylvania Code Section 6111. So what does that mean? Instead of those assets going to children from a previous relationship, we have the ex-spouse in charge of the estate administration and all of the assets flowing to that ex-spouse. Now, I can tell you in this situation, it's almost finalized, but in this particular situation, the family got together and agreed to who was going to administer the estate, and the surviving spouse gave their share of assets down to the children. So that was kind of I'd say happy ending, but not happy ending, because we had a parent pass away and an estate plan that wasn't drafted correctly on account of that spouse divorcing. There also were some income tax ramifications to receiving an inheritance and then gifting it to others. So sometimes, even if someone out of the kindness of their heart wants to do what they think is the right thing, there could be some tax ramifications to that. So again, it's really important to update your estate plan. This could have been easily accomplished when this spouse reached out to their divorce attorney, could have at the same time reached out to their estate planning attorney, updated their last will and testament on account of their intentions, and then those assets would have automatically flowed exactly where they needed to go. I will say this estate administration was not that large. I believe if it was a larger estate, like many millions of dollars, I think the surviving spouse may have changed their answer on whether or not they were going to keep all or some of those assets. So again, I don't want to alarm people because having an estate plan is better than not having an estate plan. Having good legal representation through that divorce proceeding is really helpful. Even having an estate plan before we get to that divorce, because an estate plan can also include a prenuptial agreement, a postnuptial agreement, which can set out the terms of what happens if you were to get divorced for lifetime purposes or for death purposes, so that you lay that all out there so that you don't have to go back and forth in a very difficult situation. You already sort of have the guidelines set out. Maybe Carolyn in the last couple of minutes can speak a little to pre or postnuptial agreements. What I can tell you is they are not 100% foolproof in any particular state, and there are a lot of funny provisions that can make things out automatically, in automatically. So it's not your only defense, but it is something that you may want to add to your estate plan or encourage your family members to get if you are a family with successive generations of wealth. so that you can make sure your family's wealth is protected. But again, just like the first question that we talked about today, which is, how do I make sure my wealth doesn't go to my ex-spouse? One, update your estate plan, but yeah, make sure you get trust in place for your family members so that you direct where those assets go should anyone else pass away. And go ahead, Carolyn, maybe fill us in a little bit on pre and postnuptial agreements, and then we'll let everybody go.
Sure. So pre and postnuptial agreements exist. I would say that in most cases, postnuptial agreements are sort of disfavored. The difficulty there is at law, there cannot be agreements between spouses. And so when you create this postnuptial agreement, it is an agreement between spouses. And I tell people that if you are so fixated on doing a postnuptial agreement, your best plan of action is to actually file the complaint for divorce and not try to do it before you have done that, because the consideration, meaning why, what does the other person get in exchange for agreeing to this postnuptial agreement, is the dismissal of the divorce. In other words, we won't get divorced and we will live under these terms. But again, it's a very difficult area of law. And I suggest to clients that there are better ways to do or accomplish those things rather than just work through a postnuptial agreement. As to a prenuptial agreement, I do think, and I'm seeing more and more of those, that it is a great tool to be able to set out what will occur in the event of a divorce. They require full disclosure. I tell clients, I will not do these 6 months prior, unless you're 6 months prior to your marriage date. I'm not touching it, because we need to get statements. I need to get appraisals. We may need to get a business valuation. We have to get everything very clear in terms of valuations. Each party has to have a lawyer. And it's funny because I have people say this to me all the time, but as case in point to what Whitney said, well, but I don't really have anything. Why are we doing a prenup? He really has everything and I don't really care. I don't have anything to offer in exchange. So how am I even going to negotiate this? Because I don't have any leverage. I have nothing to offer. And my answer to them all the time is, yes, you do. You have your lifetime exemption. And if this person is of wealth and that is something of value in order to shelter taxes, there's your value. I said, there's what you can offer. And therein lies provisions that we can address as part of this prenuptial agreement that you are providing value. So I just tell people, to reiterate what Whitney said, they are not foolproof. But I mean, everybody in a divorce, I say everybody sues everybody about everything. But if you did them correctly, they will be upheld. You will get the deal you intended, and they require some real thought. And I have done some very creative things in prenuptial agreements because, again, these are an agreement between two parties. They get to sort of, as long as it's not really someone twisting someone's arm or coercing or really lopsided, they are going to be enforced because the court wants parties to make agreements that they themselves have come up with and will live with. That is sort of the default. We like, at least in New Jersey, to enforce the agreements people freely and voluntarily entered into with full disclosure and knowledge, because you get to order your lives. So it is one of those things that I think is a really good tool. And if you have the time, and there are reasons to do so. Second marriages are a good example because people get concerned that I die before my spouse, all my money goes to her, she gives it to her kids, my kids are cut out. Again, trust, get a trust, go see Whitney and let's get a trust and we can fix that. The other thing that in the last minute that we have, I would say to you, at least in New Jersey, which if you don't know, in New Jersey at the present moment, we have a very significant judicial shortage. We have trials suspended in 4 counties. So even if you have an area of dispute, you will not get a trial. You will be sitting until God knows when. So I have now decided that in my agreements, whether they are divorce agreements or they are prenuptial agreements, which I think is really even more important, I include an arbitration provision. You don't get to go to court. If you are going to challenge this prenuptial agreement, you must go to arbitration, which means we will get a decision. It will occur. I don't have to worry that I don't have enough judges and now trials are suspended. And it will probably be even more efficiently done than if you were to do that in court as part of a divorce context. So That would be one of the things I would recommend if you are considering a prenup and having conversations. Include an arbitration provision. We can talk much more about arbitration in another webinar as to why I think, particularly in this day and age, it is one of the very good ways to resolve your disputes. But that was sort of a takeaway as I was sitting with a prenuptial agreement recently of what else should I be covering and adding? And I said, oh, I have no judges. So I guess I would like to do this by arbitration so that my client can actually get an answer fairly quickly and move on with their lives. So thank you all for attending.
Thanks, Carolyn. And just, I know we are at the time, but we've got one last question that we're going to answer really quickly, which is, all of my assets are held under my brother's name during my marriage. Can my spouse get his share during the divorce? And I think my first answer to that is, why is your brother holding your assets, I suppose, in the first place? Because then they're not yours. But take it away, Carolyn, I guess from a divorce perspective. And then we'll let everyone go. But I will say, when it comes to that, yes, check how you own your assets. If you have a beneficiary designation of your brother, because you didn't have children yet, those assets may go to your brother should you pass away. So it's really important to look at that estate plan, to look at how you hold your assets from time to time, whether we're thinking about divorce or there's just a passage of time.
So if the assets are not things that were acquired during the marriage, or if things were not added to those assets during the marriage, and there is a valid reason other than I'm trying to defraud my spouse, for your brother to be holding those assets, it's unlikely. It would be much more efficient, I'm sure Whitney will agree, if they were in a trust that maybe your brother was the trustee of and the sole trustee of, and with the full discretion, largely full discretion, as to what gets done with those assets. That would be much cleaner and clearer. But if a court, because we're in a court of equity in family, feels that that was done either just prior to the marriage or sometime during the marriage, they may wonder that that's really an effort to defraud or to keep assets that would otherwise be available to your spouse from them. If the assets have been held by your brother for 20 years prior to your marriage, maybe not, because then I would think there's a valid reason as to why that is the case. But, the issue becomes whether or not doing so is what they call law a fraudulent conveyance, which means you are giving an asset to a third party in an effort to avoid a creditor, a spouse, another third party from being able to get them. And the courts have the authority to void them. I have a client who was divorced in New Jersey, moved to Washington State, remarried. Everything went into his new wife's name. And the first wife, when she stopped getting her alimony because he kept saying, I have nothing, went to Washington State, and had all those transfers declared void. And so that money was then available. So does it happen often? Probably not when people have to go out of state, but it does happen. So that would be my answer.
So really important. So again, everybody, thanks for joining this month's webinar regarding your estate plan and divorce. Appreciate all the wonderful questions that came in. If there's anything else you'd like to hear about in another webinar, certainly reach out. And again, you'll get a copy of this recording, including Carolyn and my information. If you ever have any estate-related question, divorce-related question, anything in the family law realm, certainly reach out to Cohen Seglius at any time. And otherwise, everybody have a good rest of your day. If you're in a state that is raining, hopefully you are inside nice and dry, and we'll see each other again sometime soon. Thanks again, Carolyn, for joining this Lunch and Learn, and everybody enjoy the rest of your day.
Thanks, Whitney. Glad to be here. Bye, everyone.